more on this, we'll bring in lawyer and law lecturer, Dr. Justice Sremsai. It's good to see you again. We were only on last night. But listen, does this come to you as a surprise at all? Did you see it coming?
Thank you very much, and good afternoon to your viewers. Well, it did not come to me as a surprise, and I will tell you why this was so predictable. And it's entirely from the turn of events in the High Court. You will recall that the conversation between the Attorney General and Mr. Jakpa started at the time when Mr. Jakpa's concern and complaint started when his, how do we call it? The submission of no case was dismissed by the trial court. You recall, that is where Mr. Jakpa's concern started. And that is where the conversation between him and Attorney General and all the other things that turn out to be on the tape that we've all listened to occurred. Now, the only question you have to ask yourself to get to this point, to know that this case was bound to end this way, was that if the Attorney General was so confident in his case, would he have been having those conversations with Mr. Jakpa? Once you think about this question and you listen to the tape, you have no doubt in your mind that an end of this kind was about to happen. And so for me, it was only a matter of time when we are at this point where the courts would dismiss the matter. And secondly, just look at what is happening in the High Court. If you were a trial judge and all these things are happening, this tape is before you, then the Chief of Defense Staff's testimony yesterday about Jakpa's credibility and the conversation we had last night, if you were a trial judge or if you are any judge looking at this matter, what would you think is happening? Criminal trials are not supposed to be what we have seen in this case. Because the principle behind a criminal trial is that it is better to let 1,000 innocent people go than to jail, 1,000 guilty people go than to jail one innocent person. And the rules of criminal trial are said that to convict someone, if the rules are applied strictly, there shouldn't be any doubt as to the guilt of the person of the accused person. Now, if you look at all what has happened in the trial, or what is happening even after the trial judges ruling on the submission of no case, would you be proud if a person is jailed on the back of all this as a citizen of a republic, as a believer in justice? Would you be proud that someone is put behind bars on the back of all this? Clearly, that is why I think that.
I guess that's something Justice Ifeasewa would have to ponder on for time to come. But I do want to link the Court of Appeal's decision to the High Court case itself. Does it automatically truncate that one?
Yes, that is what it means. It means that the case is no longer it's no longer there because so let's go back. Submission of no case basically means that I have been put before the court. The Attorney General has been given opportunity to put all his evidence before the court. And after he put all the evidence before the court, when I make a submission of no case, what I'm calling on the court to do is that the Attorney General has not been able to prove all the elements of the offense. So offenses are defined, and in the definition, you find out that there are elements in the offense which the prosecution is bound to prove. If the prosecution is unable to adduce enough evidence to prove those elements, to show that all the elements, he has evidence to support all the elements, you make a submission of no case. And if the submission of no case is upheld, what it means is that the trial cannot continue. So when the submission of no case was dismissed by the trial court, then the accused person would have to open a defense, which means that the Attorney General had made out all the relevant elements of the offense, and which would now call on the accused person to offer explanation to the evidence. If he fails to offer, a cogent explanation to the evidence, he will be put in, he will be jailed. And if he's able to make explanation he will not be jailed. Now, what happened in the Court of Appeal is that the Court of Appeal is saying that the trial judge should have what? Upheld the submission of no case, thereby discharging and acquitting the accused persons. And since the trial judge didn't find the submission of no case to be well-grounded and dismissed it, the appeal in the Court of Appeal, which is now in favor of the accused person, is simply saying that you should have held that the trial, the Attorney General did not meet the elements of the offense and should have acquitted and discharged the accused person. But now we think that this is a proper case, submission of no case, and therefore we uphold it. And therefore, the case ought to end immediately.
I see. And I was wondering whether or not there will be any procedure followed at the High Court, because when you listen to counsels for both, the first accused person and the third accused person says, look, I need to get back to the court because I do have my documents with the court. The first accused person's counsel says this automatically truncates the case. We don't have to go there. Is there any procedure that needs to happen to formally document this, perhaps?
Yes, so the formal procedure that is required is that there must be, the decision of the Court of Appeal must be communicated or transmitted to the High Court to be aware. So, of course, the High Court will be aware of this, the trial judge will be aware because this is a public interest matter which is all over the internet and everybody is aware of it. The court itself allows media into the courtroom. However, the proper thing to be done, the procedure to be done is that the court registry in the Court of Appeal, either on the prompting of the prosecutor, that's the Attorney General, or to indicate to the High Court that this is the outcome of the appeal, which has brought an end to the case, and that will be it. To be honest, both counsel, on for the third, they are both right, because in real terms, even if the decision is not communicated, what will be the essence of anything that the High Court is doing? Have no effect at all.
I see. I do want to look at this from the perspective of the Attorney General. While there may be options for the AG to seek, an appeal on this Court of Appeal decision, would you consider it a wise one to do?
You see, the AG has been battered in this case, his reputation, his integrity, and I understand why he would want to appeal to restore, because, the case has caused a lot of reputational, questions to him and his office. And even from the trial court even made a comment, advised him to step away from the case. And so I can imagine he would definitely want to appeal, against this decision of the Court of Appeal. But the Attorney Generals hardly appeal, when they lose a case of this kind, they hardly appeal. But I see why he would want to appeal. But be that as it may, I think the news now is that the case is not going to continue. They would have to, sit down, reflect over what has happened, and take a decision which should be one that I believe should let the matters rest, because he has been battered heavily in this matter, and I think it's not good for his image, and even the justice system that he sits over, I think should not. Yeah. Indeed,
Doc. Thank you so much for your time. Dr. Justice Shremsai is a lawyer and a law lecturer. We'll stay on this subject because lawyer for Forson, Godwin Eduji Tamaklos, expressed shock over the outcome of the ambulance trial case after the court, in a surprise move, ruled in favor of the accused persons. He spoke on TV3's New Day a while ago.
Always maintain his innocence, and the vindication came to bear. The interesting thing is, with my senior, Dr. Ayene, we took him to Yoko during the investigation. And from November 2017, when we went to Yoko, they never called us again until the E-levy law was passed. And the then ranking on finance, Honorable Forson, stood up against it. The E-levy was passed, was in the budget of 19th November. 25th November, we were invited to Yoko, that they are taking us to court. So we have always had in mind that there was no basis whatsoever for this trial. And today, with the support of the Almighty God, our position has been vindicated. We are exceedingly grateful to the Almighty God and the courts